So I think we're doing the first matter by Zoom, if I remember correctly.
Partial.
Okay, very good.
In Re VOIP Guardian Partners 1 LLC. David Richardson appearing by Zoom for the appellants, and Jessica Bagnanov appearing in present for the Chapter 7 trustee.
Okay. Can we have an appearance from the appellant?
Good morning, Your Honor. David Richardson of Baker Hostetler on behalf of appellants.
Okay. All right, you have 15 minutes. If you'd like to reserve some time for rebuttal, we'll note that now.
Thank you, Your Honor. I would like to try to reserve 3 minutes for rebuttal time.
Okay, and one thing I should have said in my opening remarks, and I'll just say it here for everybody, we do have a clock. Hopefully you can see it. We rely on you to manage the time, so if you're within your 3 minutes, we're making the greatest points you want to make, you're free to go on. We can let you know when you're approaching the 3 minutes or into it, but it's your call how you want to spend the time. But we'll try to give you a heads up around 3 minutes, okay?
Thank you.
Okay, thank you. You may proceed.
I would like to begin by thanking the panel for making accommodations for today's argument.
Happy to do
What
it.
I want to do is address our main arguments, but in a chronological fashion, briefly to provide some context, and begin in early August 2019, a few days before the trustees signed the DLI stipulation. The trustee's declaration confirms that at that time, he had fully investigated DLI's lien, found it to be fully perfected with a value of over $203 million, fully encumbering all assets of the estate, and he concluded that there was, quote, no avenue for the estate's unsecured creditors to receive any distribution whatsoever. Our primary argument, of course, is that upon the petition date and a few months later, in August 2019, the trustee did not have constitutional standing to file any litigation claim that would try to recover that fully perfected collateral of DLI.
Can I stop you for a sec to make sure I've got the argument right? In my view, there's a difference, and you're going to educate me here, okay? There's a difference between, there's a darn good argument that this wasn't the trustee's money, that it really, this was more than a secured claim no matter what the documents said or they agreed later. But if that's so, isn't that the world's greatest Rule 56 motion as opposed to a standing argument?
No question that once we're done with discovery in this case, I think a 56 motion would be appropriate if it isn't resolved here.
Ain't nothing going to stop you doing that either, right? I mean, there's no impediment to you doing that.
Absolutely. We did not want to wait that long. There is yet to be more than the 2 depositions we've taken in this case 3 years into it. We wanted to bring this case to a conclusion before we all spend a lot more money.
Okay.
So if this asset had been secured real estate, the trustee could certainly have administered the asset, perhaps even sold it, but that's not an issue of constitutional standing. The loss of DLI's collateral was not a distinct injury in fact to this debtor, and therefore could not have created constitutional standing for the trustee. It makes no difference to point to language in Section 548 that says the trustee may avoid any transfer, because that's a statement of authority or power, not a grant of or replacement for constitutional standing.
Counsel, can I interrupt? And I apologize, but I think we got to get right to it, because you are making a wonderful argument. As Judge Lafferty indicated, it may be persuasive, it may be not. But why do you get to make it for the settling party? Right? We're not here to litigate that. We're here to litigate whether or not there was a valid settlement in the best interest of the bankruptcy estate, by which they're going to get over $3 million. Why is that not just outside the purview to ask us to examine constitutional standing? If the settling party thought that there might be, and I want to emphasize might be, why do we care?
Your Honor, I think we care for a few reasons. First off, the Rule 9019 proceeding was the first proceeding where we felt prepared to raise the argument at the earliest opportunity.
But it's not your money. I mean, usually the objections to the settlement is that it's not enough. Not that you should allow this party to settle and the estate to receive anything because we want to win.
But it is nevertheless a proceeding that involves these claims over which the trustee claims to have standing, and the bankruptcy court has asserted jurisdiction throughout the matter, even though the U declaration said that there isn't $1 coming back for unsecured creditors. The fact that it came up in a 9019 proceeding, we don't believe limits us from appearing to question whether the bankruptcy court has subject matter jurisdiction over these claims.
You need to develop that a little bit more.
Sure.
What is the basis? What is the strongest case on which you are relying upon?
Would be the Greektown case, the Sixth Circuit case where parties were objecting, non-settling parties were objecting to a settlement during the 1919 proceeding because it had a bar order that would affect their rights. It went up on appeal, and the court found that they had standing and addressed the merits of the issue.
Was it because of the bar order?
Yes.
Is there a bar order in this?
There isn't. No, no, there is not. But those parties were not parties to the settlement. It was not a question of whether the terms of the settlement were in the best interest of the estate. They were there to protect their interests, just as we believe we are here to protect ours. We think it would be a false distinction to say that jurisdiction, subject matter jurisdiction and standing can be raised at any time, as I-10, the Ninth Circuit's I-10 case confirms, and Arbaugh as well, but to say there's an exception to that in a Rule 9019 proceeding.
But
Well,
aren't you?
You go ahead.
You can raise those in your lawsuit. Nobody's stopping you from doing that. Somebody else is willing to pay the estate some money not to go through that. Why shouldn't the estate take it? There is no bar order that's affecting you or your client.
I have no question about with the concept that the estate would want to take that money. The question is whether bankruptcy court jurisdiction is something that can be ignored and overlooked in a case that is being pushed for nuisance value settlements, rather than be open to any challenge.
That your claim. I mean, somebody else could make that claim. You can still make that claim for your client. Somebody else made a different decision.
Absolutely, they did. But it is nevertheless a proceeding in the case. We don't think that the distinction the trustee makes between an adversary proceeding and a 9019 proceeding in the main case is a valid distinction. This is a settlement of the claims that the trustee must have constitutional standing to pursue for the bankruptcy court to have subject matter jurisdiction over. We are parties to the litigation, and we believe it's an appropriate opportunity to raise these questions and have them determined by the court.
Okay, can I give you, I actually ask you a bunch of questions to make sure we're on the same page here. I think it's been alluded to, and I don't think you're disagreeing, that pecuniarily, there's no effect on your client, one way or the other, right? I mean, you're not being barred from asserting a defense in the future if you decide to do it. You weren't barred from doing it yesterday. Had you filed the 12B1 motion yesterday, it would have been fine. So on a pecuniary basis, you're no better or worse off with this, right?
Well, I'm not sure. I agree with that.
Well, I didn't get that out of the paper, so you're going to have to help me there, okay?
As I mentioned in our papers, one of our concerns with trying to file an MSJ is we'll face a 56D motion asking for an extension because discovery is barely underway in the case. We have a judge who has said that he won't set a hearing on an MSJ if he doesn't think he's going to grant it. We're concerned that leaving this to the MSJ process could leave it in an abyss that goes on for years.
But to your very point, you can make a 12B1 motion anytime you want in the adversary proceeding. And what I'm having a hard time figuring out here is why. I mean, I hear what you're saying. You can make that at any time. That's fine. But I don't know of a case that says in a main case in which you're trying to figure out whether a settlement is appropriate and the party who's paying the money says, good enough for me, why at that point you have to try what are going to be, I mean, you can make an MSJ motion all you want, but I think the other side's going to say, we're not agreeing with those facts. They're going to be highly disputed. So the idea that you would stop a settlement hearing on something that is not only not self-evident, but is going to end up being highly disputed seems like not the procedural way I would expect this to go. So help me out with that part, if you would.
I understand it's not standard procedure, but I also don't think it's forbidden. And we cited the cases in our brief, particularly one from the Fifth Circuit. I apologize, the name is escaping me at the moment, addressing the point that the interests of third parties must be considered, not simply a question of how much value is coming into the estate.
But the harm to you is we're going to be in this bankruptcy case longer than we'd like to be. Is that? I mean, now that's kind of colloquial, but that's the gist of it, basically?
Yes.
Okay.
Yes, it is.
But what happens from this? If we agree and we say that there was error in affirming that does what for you? You say, then the denial of a settlement is then preclusive, is informative on your pending lawsuit?
Your Honor, I believe, well, it's the same lawsuit. So I believe that an order that finds that the bankruptcy court should not have approved this settlement because the trustee does not have standing to pursue these claims would be an order that would require dismissal.
But no, we don't. I'm concerned that you're reaching a little too far on a settlement motion. We're only adjudicating the reasonability of the settlement. You want a substantive determination on standing. That does not seem, we would say that, I mean, the bankruptcy court would weigh, it could go this way, it could go that way, maybe because it's going to go against you, you get less, maybe it's a stronger case, you get more. It's never there is no standing, is there?
I believe it is because the bankruptcy court made a ruling. It's held at the hearing that it has subject matter jurisdiction to make its ruling to approve the settlement of these claims. And the court can only have subject matter jurisdiction over litigation if the plaintiff has
Counsel,
standing.
isn't that the disputed issue, and isn't that one of the factors that goes into the 9019 motion consideration, is that there may be standing or there may not be standing. Other parties don't want to litigate this, and they reached an agreement. You can still raise the standing issues. You can still do that. But the parties reached if there was clearly standing and it wasn't disputed, maybe more money would have been paid as part of the settlement. But that was one of the considerations that goes into the matter when the court looks at the A&C factors and figures out whether or not they should settle it.
I don't disagree. On the other hand, I don't think there is a single case out there that says that subject matter jurisdiction or standing are not appropriate for a Rule 99 proceeding, that it is somehow outside of the Arbaugh rule, the I-10 rule.
But can't the judge decide that it's undecided and therefore it's a factor? Does the judge, you're saying that the judge has to decide first that he has standing, but that was an issue that was in dispute, and that's why the case was settled.
But this judge did stay on the record. You can't deny that I have standing for this matter.
But that's not an issue before us. We're not concluding this. We're not concluding whether or not there's standing.
Your Honor, I don't think that it's disconnected from subject matter jurisdiction. If the court is saying I have subject matter jurisdiction to decide this settlement, it has to be because there was standing for the plaintiff to pursue the claims in the first place.
But counsel, my understanding from your argument in your briefing is that, one, you acknowledge that it was a secured creditor relationship. It was secured debt, right?
Yes.
So ordinarily, the title remains with the borrower in that situation. You are arguing that based upon the facts that you are now discovering or have discovered, that there was some alteration of that relationship. And Judge Corbett's point, isn't that the factual? I mean, if it was a debtor-borrower-creditor relationship secured, that is the basis for the jurisdiction, is it not? You may dispute it, and you may win, but even under your paradigm, isn't that enough to get you to the point that the trustee wants to get?
I don't believe it does, Your Honor. It is bare legal title over funds that were simultaneously...
You have to prove bare legal title. That's the problem.
And I think the terms of the DLI stipulation, which have been before this court for 4 years, prove it on its face.
But
immediately...
Just for what it's worth, you're into your 3 minutes. If you'd like to reserve what's left, that's fine. If you want to go on, that's fine too. It's totally up to you.
I would prefer to deal with any questions the panel has, Your Honor.
Okay. I'm ready to pause unless my colleagues feel differently. Okay. We're ready to pause if that's okay with you.
And I'll save
Okay.
the last.
All right, then you can give us a wonderful rebuttal after we've heard from the Trustees Council. Thank you.
Thank you, Your Honors. May it please the Court, Jessica Bagdanov on behalf of Tim Yu, the Chapter 7 trustee. I'll start, if I may, where my opposing counsel left off, which is his citation to the Fifth Circuit case. I think he's referring to Feld versus Yale Corporation, cited in his brief, Your Honors. Mm-hmm. And that case says, certainly, you need to look, it defies fairness to not consider the rights of third parties in approving a settlement. And the case goes on to say, where the rights of one who is not a party to the settlement are at stake, the fairness is not enough. That's the issue here. that your honors have pointed out. Their rights are not at stake. The same was true in the Greektown case. That case dealt with a bar order that affected the rights of the non-settling defendants. It's the same in Smith versus Arthur Anderson, your honors, where the non-settling defendants were faced with being prevented from asserting indemnity rights. Those settlements affected the appellants or the non-settling defendants.
So
And-
you're, not to cut you off, but just so we know where we are here for everybody in the room, where the adversary has been focusing really on the trustee's standing, your point is you don't think the appellant had any standing at the bankruptcy court, correct?
That's correct, and your
Okay.
honors, that was an intentional act by appellants in this regard. They filed a special appearance. They are specifically not creditors to this estate, and that was an intentional choice on their part. And
Because, I mean, the ruling, the primary ruling from Judge Russell was, why do you, appellants here, have standing?
Right,
And it was
and
a fairly quick hearing, and he made his decision rather quickly, as Judge Russell sometimes does. And there we are.
yes, Your Honor, and that's
Okay.
absolutely right. And I think this goes back to one of your introductory comments that you made that I thought was interesting to focus on. What do you think this panel can do about it versus I disagree with the judge below? And I think in this regard, appellants are missing what Judge Russell talked about at the hearing, and it may have been quicker than they had preferred, but he did address their arguments and disagreed with them pretty openly. And he said at the hearing that if it comes up in another matter, the jurisdiction issue, that will be for the other matter to deal with. My only ruling today is that I think the compromise is fine. I view it beneficial to the estate, and I certainly have subject matter jurisdiction. You can't seriously argue that because we're talking about a Rule 9019 motion, which is a core proceeding under the Bankruptcy Code.
So going back to sort of my little checklist, with respect to the appellant here and the objecting party in the bankruptcy court, I think everybody agrees that they're not affected monetarily by the settlement. And if they have liability, they will have liability, and that'll be separate and apart, because that's how these things play. I mean, this whole Ponzi scheme notion and clawing back monies is something that's particular to each defendant. It depends on what they got. There's no pool, right? And
That's
it's not
correct.
about that. It's about to what extent you're going to end up proving or otherwise resolving the question of how they took the money, whether it was actual or constructive and so on. And that's unique to each. So they're not monetarily affected one way or the other by the settlement. Okay.
That's absolutely correct.
And,
Your Honor.
and secondly, to the extent there was any worry, and there could well have been, and I'm very sympathetic to this, if there was some sort of explicit or implicit worry that, well, the judge is blessing the notion that this would play out a certain way, that this is a secured credit and this is a rational settlement, based on all the things that you'd have to conclude to get there. But everybody seems to be agreeing that there's no preclusive effect, including Judge Russell, and including, if I read your papers correctly, you, right? There is no preclusive effect here one way or the other. And I think that to the extent there was an interesting law of the case argument made at the bankruptcy court, I don't think that's presently being pursued.
That's correct.
Okay.
I read appellant's briefs similarly, actually.
Okay.
And at the bankruptcy court level, the premise or the focus was really on prudential standing, that there may be law of the case. There may be an issue of losing a right going forward, and that was quickly dispelled and interestingly not made before this panel. The issue now is more toward perhaps the panel's citation to East Coast Foods and really turning this into an Article 3 standing issue. And I really submit to your honors that you hit it on the head in saying this doesn't affect you, and what can you do about it? And that really goes to the third element of the Lujan test of Article 3 standing is what would happen?
This is redressable.
Is it what is here? What will happen to these defendants? And I think it bears repeating what claims were settled by virtue of the trustees' settlement with the Omanoff parties. We had breach of fiduciary duty and damages and an aiding and abetting claim, avoidance of 2- and 4-year fraudulent transfers under sections 548 and 544, a few preferences under 547, a few post-petition transfers under section 549, recovery of transfers under section 550, and claim disallowance under section 502. The massive majority of these claims are section 500 claims that arise solely by virtue of a bankruptcy case being filed. So
So that's, I mean, you're going back to my first question. Is this really a standing issue, or is it a Rule 56 issue, that the trustee simply, can't exercise these powers because it wasn't the state's money?
Sure.
Okay.
As to this panel, Your Honor, I think it's an Article III standing issue.
Yeah.
As to Judge Russell, it's absolutely a Rule 56 motion.
Yeah.
And if there is a silver bullet on jurisdiction, you don't have to wait until the end of fact discovery in a complex litigation case where we're trying to recover $200 million to bring your jurisdictional motion.
Does that go to the second element of the Article III standing?
That there's no
Well, the one, that there's harm, two, that the harm is caused by an act of the court.
Correct.
Right, okay. What you would say is if your worthy opponent here could have made that 12B1 motion a month ago, a day ago, or tomorrow, whatever the harm isn't caused by the court, because he has the ability to do that, correct?
Absolutely right.
Okay.
And I dispute my opponent's comment that Judge Russell has accepted jurisdiction. Certainly, he is presiding over an adversary proceeding,
Yeah.
but it's not like he's denied a motion for summary judgment on the basis of subject matter jurisdiction. Nobody's brought it.
Or a 12B1 motion.
Yes.
Okay.
And so we have here, and as Your Honor pointed out, when you have Section 500 claims against multiple defendants in the same adversary proceeding, you're going after different money. It's different corpuses of monies that each defendant received. So there is no injury, financial or otherwise here, except that they are still parties to the litigation.
Yeah, this is not joint and several in any sense, right? It's what did you get and can I get it back?
Yes.
Yeah.
And there is a fiduciary duty element to this
Okay.
analysis, and the trustee alleges that certain of these appellants were officers and directors of the company, and so if there's a damages allocation, it would reduce the damages that another party would owe, but that's not what we're doing here. We settled with the Omanoff parties for a corpus of money, and we proceed, and they are no longer parties to the litigation. It has absolutely nothing to do with them. And I think here we have the appellant saying, I have the right to raise subject matter jurisdiction at any time that I want, which is true in the adversary proceeding. Here, you don't get to make it in any place that you want. And when you're not a party to a bankruptcy case and the settlement does not affect you, there's no exception to the standing element that Smith versus Arthur Anderson discusses in these other cases about it needs to affect you in order for you to have standing to question it. And even if they did have standing, the trustee takes serious issue with the fact that the bankruptcy court would not have jurisdiction over Section 500 claims, but you don't have to get there because there's no standing. And interestingly, to the substantive piece of their case, a point unaddressed in their briefing is really the trustee's citation to BFP versus Resolution Trust that talks about how interest in property of the debtor, the element under a fraudulent transfer claim, is not a jurisdictional prerequisite, is an element that the trustee has to prove by a preponderance of the evidence, just like the other elements. And if we can't prove it, I guess we'll lose at trial. Or
Your point is really that it's not standing, it's more property of the estate even, right? That by virtue of the facts being posited by your opponent, the debtor's interest in the property given to secure a debt somehow transmogrified into property owned by DLI.
Right. It happens all the time where a secured creditor has a perfected lien in all assets of a debtor. Does that extend to Section 500 claim recovery? No. Does it extend to breach of fiduciary duty recovery? Maybe. That's not on trial today. Nothing's on trial today.
Well, and to go slightly, it's certainly not Kaplan, for example, right? I mean, Kaplan was about something very different.
Correct.
Okay, so I mean, this is right down the middle of the, facially, these are the trustee's claims and nobody else's.
Right, and the trustee also disputes that DLI was the only creditor. The claims register in the bankruptcy case belies that fact. There's claims out there, and in fact, this settlement settles one of those claims and provides for that claim to be subordinated to other allowed unsecured claims. So can the trustee enter into a carve-out agreement with a secured creditor? Absolutely. Nothing is interesting about that. It happens all the time. And
Well, it might be interesting, might not be objectionable.
right, right. Well, exactly.
Yeah.
Yes. And so I think in this regard, the appellants have really briefed themselves into a corner in arguing prudential standing at the bankruptcy court, realizing that that is no longer the best argument to make, and instead focusing on my injury is a risk of real harm and increased economic burdens due to the bankruptcy court's order, and citing to the Ninth Circuit case of In re Sisk, which is a highly unusual case. I hadn't been aware of it before, where a Chapter 13 debtor is proposing a plan and the bankruptcy court denies it and is foisting these other choices on the debtor to remain in bankruptcy longer, to make its plan longer. And the real issue before the Ninth Circuit was whether a Chapter 13 debtor can include an estimated plan consummation time or not. That's the holding of that case, that you can include an estimated time for confirmation. And it has nothing to do with these facts. In that case, that was a debtor being faced with, do I have to stay in bankruptcy for 5 years or for 3 years, really watered down. That is not this case. You have rights in an adversary proceeding as a defendant if you don't want to be there. And if you have a jurisdictional argument that is an absolute winner, bring it. And I think the case law says at the earliest opportunity. Your Honors, unless you have further questions for me, I have nothing else, and I respectfully request that the court affirm the bankruptcy court's order on Article 3 standing and on its merits as well. Thank you, Your Honors.
Thank you. Okay. Mr. Richardson, you've got a little over 2 minutes.
Thank you, Your Honor. I just want to address briefly how we got here, at least from our perspective. Because there is so much case law saying that non-settling defendants do not have standing to object to a settlement as to its terms, we addressed the preclusive effect argument in our motion. In disagreeing with us, the court applied half of black letter law, saying that you are not affected because jurisdiction can be addressed at any time. But as we explained in our brief, the other half of the court said jurisdiction's never waived. The other half of it that the court did not address is that a party can challenge jurisdiction at any time. And we believe that was the error on our standing question. And we believe that is the error that has injured the parties, to whatever extent preclusive effect is required. Because we should have had the opportunity to challenge standing at this time, in connection with this settlement, but the court deprived us that right by only recognizing what is half of the black letter law. If the panel has any other questions, otherwise I would submit.
Thank you very much. Thank you both for your good arguments. I think the externs and law clerks who are here today are going to be impressed by how important it is, as convoluted and wonderfully complicated as our matters can be, to really focus down on the basics. And there are a few things more basic than standing, and you've given us really fun arguments about a very fundamental issue today. So thank you both very much. Really appreciate it. The matters submitted will get you a written decision as soon as we can. Thank you very much. And good luck later today, Mr. Richardson.
Thank you, Your Honor.
You're welcome.